Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. The Wall Street Journal this morning published an explosive article claiming Donald Trump's personal lawyer, Michael Cohen, paid a firm to rig two popularity polls, one run by CNBC, the other by the conservative site, the Drudge Report. As soon as the article was published, Michael Cohen sent the following tweet. As for the Wall Street Journal article on poll rigging, what I did was at the direction and for the sole benefit of Donald Trump. I truly regret my blind loyalty to a man who doesn't deserve it. The revelations stem from the charging document filed by prosecutors against Cohen. The document references that Cohen sought reimbursement from the Trump Organization for $50,000 he spent on tech services for the Trump campaign. The Wall Street Journal claims the tech services company is Redfinch Solutions LLC, owned by John Gower. Now, when Cohen requested the $50,000 reimbursement for tech services, he apparently didn't tell the Trump Organization what specific services were performed, and it didn't ask. Cohen had already pled guilty before today's revelations to campaign finance violations, tax evasion, lying to Congress, and other charges. He was sentenced last month to 3 years in prison. None of those charges were connected to this alleged poll rigging that occurred a couple of years ago. Gower told the Wall Street Journal that his activities related to Trump consisted of trying unsuccessfully to manipulate two online polls in Trump's favor. Now, is this $50,000 payment to the tech firm a campaign expense? That means an expense made by the Trump campaign for the purpose of influencing an election. If so, it should have been reported. Because it wasn't reported, the Trump campaign, typically its treasurer, may have some liability here. If Cohen contracted and paid for these tech services himself without coordination with the Trump campaign, which that doesn't seem like that's what happened, then that would be an independent expenditure. Cohen, as a private person, may make independent expenditures on behalf of political candidates and their campaigns. Individuals, political parties, unions, corporations, PACs, and other groups making independent expenditures, however, must disclose the name of the candidates who benefit and must itemize the amount spent in a report to the FEC. Cohen did not make such a report, so he could have some liability there if it's an independent expenditure, but I don't think it is. It appears Cohen was reimbursed by the Trump Organization for the payment. So did the payment come from the Trump Organization? If so, may the Trump Organization, which is a corporation, make independent expenditures on behalf of political candidates? Yes, thanks to Citizens United, the Supreme Court decision. And the Political Candidates Campaign Committee has nothing to do with independent expenditures, and so doesn't report them. So the lack of reporting by the campaign of an independent expenditure by the Trump Organization or by Michael Cohen is not a problem. But the Trump Organization would have had to report it, but it didn't. So that could be a problem with the Trump Organization if this is an independent expenditure, but I'm not sure that it is, and I think it likely is not. Anyway, if Cohen coordinated with the campaign, I'm going through all these scenarios. If Cohen coordinated with the campaign, then the campaign would have been required to report the $50,000 payment as an in-kind contribution. That the campaign didn't do that means that would constitute a violation of campaign finance law. Furthermore, federal law imposes a $2,700 limit on in-kind contributions to federal candidates. Obviously, $50,000 is more than $2,700, so there's another potential violation of campaign finance law if it's an in-kind contribution. Now, Cohen claims he did this at the sole direction of then-candidate Trump. If he did, that would also be a problem for the campaign. Now, let's look at the two polls in question. One is from January of 2014. Cohen asked John Gower to help Trump score well in a CNBC online poll to identify the country's top business leaders by writing a computer script to repeatedly vote for Trump. Gower was unable to get Trump into the top 100 candidates. Now, that poll has nothing to do with federal elections. It was done a year and a half before Trump even became a candidate, so there's no legal liability there under a fair reading of the statute. Now, prosecutors in the Southern District of New York or in Robert Mueller's Office of Special Counsel may have a different interpretation, but if they do, their interpretation would be wrong. Now, the second poll, that's the problem. In February of 2015, as Trump was preparing to enter the presidential race, Cohen asked Gower to do the same poll rigging for a Drudge Report poll on potential Republican candidates. Apparently, on that poll, Mr. Trump ranked fifth with about 24,000 votes, or 5% of the total. Now, this could be a problem for the Trump campaign and those affiliated with it. Trump did not declare officially as a candidate until he filed his statement of candidacy in June, on June 22nd of 2015, several months after the alleged poll rigging. So Trump was not a candidate when Michael Cohen arranged for these services from Redfinch. That $50,000, if it's an in-kind contribution, if that's what it was, that would have triggered the responsibility by then private citizen Trump to register as a political candidate and register his candidate's campaign committee and report that as an in-kind contribution. The same goes if Cohen was actually an agent for the campaign that was being put together. If that's the case, it's not an in-kind contribution, but in fact a direct expenditure by the campaign. But because the amount was over $5,000, that triggered Trump's responsibility to form his campaign committee and report that $50,000 expenditure, whether it's a direct campaign expenditure or an in-kind contribution. And that could be the problem. So as you see, Trump may have some liability here. Now, we'll keep you posted as the story develops. But one thing I'm sure you have taken as a result of this video is that campaign finance law is extremely difficult. It's very tricky and it's very hard to navigate. If you intend to become a candidate, if you work for a candidate, if you intend to form a political action committee, a campaign committee, a political committee, or if you run one and you need some legal advice, give us a call at Scaringi Law 717-657-7770. I handle campaign finance and election law for the firm, and we'll be happy to speak to you. Well, that's about all the time we have today for the Scaringi Law lunch break. I hope you learned a little bit about the law. Thanks for listening, and enjoy your lunch.